Very good evening to all the participants and hearty welcome to our young and dynamic senior research fellow and the resource person of today, Mrs. Srinidhi. And I have great pleasure in introducing the young scholar to all the participants. Ms. Srinidhi is a UGC senior research fellow right now, pursuing her doctoral research at Department of Law, Osmania University. And her topic of research is standard essential patents. Probably it is one of the few subjects in respect of which many may not have a clear idea. And she readily accepted when we requested, even though we gave her very short time. We must thank her to in fact, come to our rescue and to deliver today's lecture. A brief intro is, she is a product of University of Petroleum and Energy Studies, Dehradun, having obtained a B.A.LL.B degree, where she specialized in energy laws. Thereafter, she went on to pursue her LL.M in intellectual property rights from NALSAR University, Hyderabad, and she has qualified for NTA-NET, that is UGC-NET, and has also secured the JRF granted by the UGC. And previously, she worked with Alliance University, Bangalore as an assistant professor, and she also handled subjects like public international law, intellectual property rights, jurisprudence, so on and so forth. Her special interest lies in the areas of patent law, copyright law, public international law, and constitutional law. And she has published a number of research papers and book chapters in reputed journals and other publications, and also a very keen participant in several national and international conferences. And recently, in fact, she has contributed a very good article in an edited book being published by DPIIT IPR-Chair, Osmania University, called Licensing of SEPs in the 5G Era. And she has also presented a number of research papers in the national seminars, including the National E-Conference on IPRs, then conducted by ICFI Law School, Hyderabad. She has also written a book chapter, in fact, entitled Standard Essential Patents, Shift of Perspective from Patent Holdout to Patent Holdup, in the book titled IP Rights, Issues and Implications 2022 by ALT Publications. She is the right person to talk to you about the standard essential patents. So now I would be requesting Ms. Srinidhi to make her presentation. And as Srinidhi knows, most of these participants, there are about 50 plus participants here. They have been very loyal, regular IP enthusiasts for the last 26 weeks. And this is our 26th week of interaction in the Know Your IP series. And this video will certainly be part of our YouTube channel of DPIIT IPR-Chair, IPR blog, and it will be seen and visible everywhere in the world. So without taking much of your time, now I request and invite Ms. Srinidhi to make a presentation. Over to you, Srinidhi.
Thank you so much, sir. Thank you for this opportunity. Even though I'm just a student, you still invited me, and I'm very grateful for this opportunity. Hopefully, I live up to that. But I have researched on SEPs in the past couple of years, so I will put forward my thoughts. I'm going to talk about standard essential patents, an overview. So my aim of this lecture is to give you, basically introduce you to standard essential patents and give you a little interesting details about the topic. This is the outline of my presentation. Okay, so first I want to begin. The topic is standard essential patents. It only makes sense to start with standards. So what are standards? Standards are everywhere. They're ubiquitous. We use standards every day. They make our life easy. From the moment we get up, you get up and you know the sun will rise at 6 a.m. Your day is standardized. It will set at 6 p.m. That is standardized. You can go about your day in between that time. Then you get ready, you go to work, you use your GPS system to go to college or work. It says, for example, it says 4 kilometers. So that kilometer is standardized. Then you go to work, you open your laptop, and that laptop has thousands of standardized technologies. Your smartphones have thousands of technologies. So at this point, we cannot imagine our life without standardization. So a standard is a set of technical specifications that seeks to provide a common design for a product or a process. That means that how many ever times you repeat something, you should get the same result, and standardization ensures that. So standards have been used since ancient times. Standards have been found even in the Indus Valley civilization, as old as that, and we've been standardizing since official standardizing since 17 to 1800 years. So that's how all pervasive standards are. So they ensure consistency, reliability, and facilitate dissemination of technology. So if you open your laptop and you connect to Wi-Fi, it will connect. Your laptop will definitely connect to Wi-Fi. If it stops connecting to Wi-Fi, you will probably not use your laptop. So that's how consistent standards are. Then they help in increasing global tradability and compatibility of products and services. When you follow an international standard and you manufacture, say you are a smartphone manufacturer, say you are something like Oppo, Vivo, or Micromax, you want to manufacture a product, you'll obviously follow international standards. When you follow international standards and you make a product, it will obviously have global tradability, and it will be compatible with other products as well, which are also standard compliant. How are these standards developed? They're developed through a process of consensus and generally by a standard setting organization. For example, International Organization for Standardization, ISO, is a very popular standard setting organization. Standards are developed in two ways. There are de jure standards and there are also de facto standards. De facto standards emerge from the market. That means they're so popular that they become a de facto standard. For example, you have your Windows as operating system. And Windows as operating system is so popular. It's not like there are no other operating systems available. You have Linux, you have iOS, but still people still use Windows as operating system because it's easier to use, it is friendly to use. For whatever reason, Windows is popular. So what this happened, this became a standardized operating system. All the different manufacturers of laptops, they wanted to have Windows in their laptops because it's popular. That's how de facto standardization works. Similarly, Adobe's PDF. There are other PDF readers. There's so many other PDF readers, you probably don't even know the names. But Adobe PDF, we all know because that is the only document reader we use mostly. So that has become a standard. And most standards are developed in a formal manner or de jure manner, and these standards are developed by standard setting organizations. So there are standard setting organizations, especially in the ICT sector, in the telecommunication sector, called European Telecommunication Standards Institute, International Telecommunication Union, Telecom Standards Development Institute of India. This is our local standard setting institute. Then I want to talk about standards in the ICT sector. So in the ICT sector, in the information and communication technology sector, standards have helped immensely. The fact that there's so much dissemination of technology, you see a smartphone in the hand of even a school student to an old person. So that's how that's how standards helped in dissemination of the technology. The fact that we are able to use our phones to connect to the internet, we download apps, we do all these things because everything is standardized there. In the ICT sector, standards help in achieving this important function called interoperability. Interoperability refers to the ability of two competing devices being able to interact with one another without any prior customization. Okay, so for this, I will give you a small example. You have your Your laptop will connect to the Wi-Fi, your phone connects to the Wi-Fi, and your tablets also connect to the Wi-Fi. How is that possible? Because there is a standard setting organization called Institute for Electrical and Electronic Engineers, which developed these Wi-Fi standards. They said if anybody wants to use wireless internet, they have to have these Wi-Fi protocols, these internet protocols in their systems. Only if they have these protocols, they will be able to access this wireless internet. So what did the manufacturers of these laptops, tablets, and mobile phones did? They went to that organization and they sought a license, and after they got the license, they incorporated that technology into their devices, and that's how we are able to use those technologies. So again, even in the ICT sector, the standards are developed through a process of cooperation and collaboration between the standard setting organizations, the SCP holders, and the implementers of the SCPs. I will explain in detail who these three entities are. So in the ICT sector, standards such as Wi-Fi, Bluetooth, 2G, 3G, 5G, these are some notable standards in the telecommunication industry. So there's certain benefits of standardization. How since I'm talking so much about standardization, there should be some benefits to it, right? So benefits of standardization include, firstly, the SCP holders, that is the persons who own the patents to these standards. They are called SCP holders. They're rewarded for their research and development. And when they're rewarded for their research and development, they have an incentive to innovate. And when they have an incentive to innovate, they will come up with more technologies, more similar technologies, or even better technologies. So this is how SCPs help, standardization helps, that the SCP holders are rewarded for their R&D. Then it promotes interoperability between competing devices and also promote international trade. I already discussed this. Interoperability is the ability of two different machines, two different devices manufactured by different different manufacturers. So your phone made by Oppo, Apple, Micromax, and any other manufacturer, all of them are able to function in a similar manner. All of them will be able to click a picture, all of them will be able to connect to Wi-Fi. Why? Because they're standardized. They have certain standardized technologies in them. Then consumers benefit from the low cost and have access to variety of standard compliant products. So when a technology is standardized, say you have again, I'm taking the example of Wi-Fi. Since Wi-Fi protocols are standardized, consumers will have access to quality products. Consumers know that if I'm buying the cheapest of the phone, even if I'm buying a smartphone worth of 6,000 rupees, my phone will still connect to the Wi-Fi. Even if I'm buying an iPhone costing 1.5 lakhs, it will still connect to the Wi-Fi. That is the minimum quality assurance consumers have. And that is happening thanks to standardization. Then implementers, licensees get access to patented technologies. They do not have any need to invent around. So implementers or licensees are the mobile device manufacturers. If they want, since suppose there is a small player, say like Micromax, it's a smaller manufacturer. Even manufacturers like these Chinese manufacturers like Oppo and Vivo, they also do not have the capability to develop technologies. Technologies are generally developed by big software companies like Ericsson, Qualcomm, Huawei. All of these companies develop softwares, but these companies do not have, these manufacturers do not have the resources to, or the R&D to develop new technologies. So for them it becomes easy because they can simply license these technologies from they can simply license these technologies from these SCP holders, this Qualcomm, Ericsson, all these people. They do not have to invent around. Suppose there was no possibility of license. There was no standardization, hence there was no possibility of license. Then what will they have to do? They would have to invent around it. So suppose if there is, a certain way to connect to Wi-Fi, they will have to find another way to connect to Wi-Fi. This would have taken a lot of time and effort, and this would also have reduced, access to consumers. They would not have had variety of products, and that would have led to monopoly, and that would have in turn had some effect on competition and then innovation also. So these are the benefits of standardization. Then we look into what are standard essential patents. So we discussed what are standards. Then I told you what are standards in the ICT sector. Now we'll do what are standard essential patents. In simple terms, simplistically speaking, patents which are essential to implementing a standard are called standard essential patents. So, for example, these are, I'm talking about 5G standard essential patents. These are all the companies which have 5G SCPs. These are all the companies which have 5G SCPs. So you can see the table. Huawei has 14%. Samsung has 11%. So this data is 6 months old, but in the ICT sector, this is really still older data. So if I look at it today, probably the numbers would have interchanged. But for example purposes, I took this data. So so what happens is, if any manufacturer wants to have 5G in their handsets, everybody wants to have 5G in their handsets, because in the coming times, if you do not have 5G, probably nobody will even buy your phone. So what happens is, all these people have standard essential patents. So these manufacturers will license their recipes to the manufacturers, and then they will have access to these standard essential patents. So there are technologies around which alternative methods cannot be invented. So there can be only one 5G. You cannot have any alternative to 5G. You have to use those patented technologies. In other words, one cannot implement a standard without infringing the said SCP. ICT products such as smartphones and laptops must meet many standards and require the patented technologies to manufacture them. Manufacturing these standard compliant goods without employing these technologies covered by SCP is impossible. For instance, any smartphone manufacturer willing to implement the 5G standard in their handset should comply to the 5G standards required by the standard setting organizations. So this 5G standard is set by an organization called Third Generation Partnership Project. So they tell you the specifications, and the local SSOs adopt those specifications and make them into standards. So all the manufacturers will have to adhere to those standards if they want to manufacture standard compliant products. So how are standard essential patents created? How do they come about? They come about because of these entities called standard setting organizations or standard development organizations. They're responsible for the development of standards for users of SCPs. Okay, so what do? They're engaged in developing, coordinating, promulgating, revising, amending, and interpreting standards which are applicable to a wide base of users or implementers of standards. So how do they do that? First, what happens whenever there's a standard setting organization present? So you have your ETSI, the European Standard Setting Organization. If you take an example of that, what they do is, whenever they decide to develop a standard, for example, assume they are developing a standard for 5G. So what they do, they invite their participants, all the participating members, to declare if they have any relevant patents, related to 5G. So who are these participants? These participants are generally these software companies like Ericsson, Qualcomm, Huawei, and there's some Chinese companies as well. So these companies are generally the members of these standard setting organizations. Apart from these people, there are other stakeholders also involved. Sometimes even manufacturers are a part of this standard setting organization, and sometimes even governments are a part of the standard setting organization. So these SSOs invite the participating members. They say, if you possess, if you own any, SCP, if you own any patent related to 5G, please let us know, and we will check and we will include that in the 5G standard. So, and generally owners of such patented technologies, they want their technology to become SCP, because why? Then they will have access to a bigger market. Then they can make more money by licensing their software to so many other manufacturers. Okay, so owners of such patented patented technologies compete for the inclusion of the technology into the standard, SSOs through deliberation and consensus choose relevant patented technologies to be a part of the standard, and these become standard essential patents, and the owners of these patented technologies are called standard essential patent holders. So if you see the figure on the screen, so they're standard setting organizations, and these standard setting organizations, they invite participants to disclose if they have any, patents which are relevant to the 5G standard. They say, please tell us, and we will check and we will include that in the 5G standard. So then once they're included into the standard, they become from regular patents, they become standard essential patents. Why? They're essential to implementing that standard. Then you have SEP holders. Then the entities or the people who own those standard essential patents are called SEP holders. And the entities or the companies which which ask for license, who want to include that standard, that 5G standard into their phones, like manufacturers, product manufacturers, they're called SEP implementers. So you have a standard setting organizations which facilitate the whole process of standardization, who act as a bridge between the standard holders and the standard implementers. Then you have SEP holders who own the standard essential patent, and who are willing to license the standard essential patent to others. Then you have SEP implementers who want to use that technology, who want to license that technology. So this is how the standards are created. Now the question of licensing of such SEPs comes. So till now there is no problem, everything runs smoothly. You have your standard setting organizations coming to, inviting participants to declare their patents as SEPs, and then the standard is made, and then the standards holders, SEP holders, also agree that yes, we will license, and then and the licensing has to take place. Now, how does it take place? Once the standards are set by the SSO, implementers would want to manufacture products complying to the standard, as products which are not standard compliant are liable to fail because their device will not interoperate with the other devices in the market. So if you ask me, why are these manufacturers so eager to include that standard into their mobile phones? Why does somebody want 5G in their mobile phones? Because if they're not compatible, if they're not compatible with other devices, they won't interoperate, and if they don't interoperate, their products would become unmarketable. For example, would you buy a phone which does not connect to Wi-Fi, or would you buy an Android phone which will not be able to call an iPhone? You will not buy that phone because it will become as good as useless to you if it doesn't connect to Wi-Fi, if you're not able to call somebody. So this is how important interoperability becomes. And then that is why manufacturers want to include their standard into the, that standard into their mobile sets. This effectively means that any implementer willing to manufacture a standard compliant product will have to seek licenses from the SEP holders. So here you have these SEP holders who are who are in a little, who are in a position to license, and you have these SEP implementers who want the license. So if you look at the power dynamic here, you understand that the SEP holders have slightly higher bargaining power in the market, for the sole reason that they own the patent which is essential to that standard. And these SEP implementers, they are in a position where they want to manufacture. They probably invested a lot of money already in it. They must have already, began manufacturing because this technology is only a small part of the phone, but they must have probably manufactured or invested enough, in manufacturing already. So they are in a position that, in a desperate position, they want the license. So this situation puts the SEP holders in a dominant position in the market, because they are in a position to refuse the license. They can say that, I will not license my SEP to you, because at the end of the day, he's a patent holder under patent law, and he's free to license or not license his patent. He'll say, I don't want to license. I will only have the technology. I will develop the technology. I will manufacture the end product also. If he says that you cannot do anything, so to remedy this situation, standard setting organization said that, while when after they invite going back to the standard setting process again, they say after they invite these participants to ask if they possess any standard essential patents, they will say that once it's declared as standard, once your patented technologies become SEPs, once they become essential to the standards, they say you have to either make them royalty free. You license them and you do not take any royalty fee. But if you're taking royalty fee, you have to license it on terms which are fair, reasonable, and non-discriminatory. In short, these are called FRAN. Why? Because it's fair for F, R for reasonable, and then N for non-discriminatory. So this becomes FRAN. So Bluetooth, USB, and HDMI technologies were royalty-free technologies. So that was not a problem. But your 3G, 4G, 5G, Wi-Fi, and your LTE, so many other technologies, they are not royalty-free. You have to pay a price to license those technologies. So the SSO said, if you're going to license these technologies, you will have to license them on fair, reasonable, and non-discriminatory terms. Otherwise, we will not include that in the standards. So this FRAND, in ideal situations, will help both the parties. It will help the implementers to the standard that they will have accessible to technologies with reasonable royalty rates. They will not have to pay excessive royalty rates. And it will also allow SEP holders to recover costs of their research and development they incurred while developing the patented technology. So, in ideal situations, this is what FRAND is supposed to do. It's supposed to help both the licensors and the licensees as well. So, coming back to what is FRAND. FRAND stands for fair, reasonable, non-discriminatory. And like I discussed, SSOs require SEP holders to license their SEPs on these terms. Then FRAND is a voluntary agreement that SSOs require SEP holders to adhere to. So FRAND is a voluntary contractual agreement which the SSOs and the SEP holders, with the standard setting organizations, and the implementers of this and the SEP holders, they both of them enter into this contract saying that, yes, my in exchange of you declaring my patented technology as a standard essential patent, I will in exchange of it, I will license this. I will license this on FRAND terms. The meaning of FRAND is not defined anywhere. So here comes the tricky part where the FRAND is not defined by any SSO. So this creates problems when these FRAND disputes go to litigation, because you don't know what is fair, reasonable, and non-discriminatory, because these terms, even though very intuitive in nature, like you think you know the meaning, but since they're not defined anywhere, courts do not know what to refer to. For example, for me, maybe 2% royalty fees on the end product is reasonable. Probably for another person, 1% is reasonable. So this problem is called FRAND for one is not FRAND for all. What is FRAND for me? What is fair, reasonable, and non-discriminatory for me might not be the same for another person. So this could lead to disputes. So if you have to define what is fair, probably it means, fair could mean equitable set of terms which allow for free competition, terms which are not anti-competitive or unlawful in nature. That could be the meaning of fair. And reasonable refers to probably reasonable royalty rates. rates which would have been paid if the transaction between the FRAND holder and between the patent holder and the infringer were voluntary. So reasonability comes here, where you it is assumed that if you take them, if you remove them from this SEP system, and if they were licensing, privately, then the rates which they would have come to would be a FRAND rate. Then you have non-discriminatory, charging the same royalty rate for all implementers, or probably, not discriminating while giving licenses. You cannot say, I will not license to my competitor, or, I will not license to another company for whatever reason. So you have to license to everybody. But these definitions are not given anywhere, neither the SSOs nor the laws, nor any IPR policy does not define FRAND. So the ambiguity of these terms has led to a massive litigation in these areas, because FRAND for one is not FRAND for all, and determining acceptable FRAND royalty rates has led to smartphone wars or friendly wars. Although there is nothing friendly about it, it is just nicknamed as friendly wars. Since SSOs do not define these terms, courts have attempted to define these terms across jurisdictions. So all this litigation occurs because both the parties cannot agree on one FRAND rate. Because what is FRAND for the SEP holder might not be FRAND for the SEP implementer, because the SEP holder tries to get as much as he can in royalty rates, because that is the only way he's going to recover the R&D. And to be fair to the SEP holder, developing these technologies takes a lot of money, capital and investment, and a lot of time as well. And for the implementer, if you see the situation of the implementer, he's in a deplorable state. Why? Because he has no other way than to implement the standard, because the standard setting organization said that you have to have the standard, and then he has no other go. He wants that standard, but he cannot afford that standard. So in those cases, litigations happen, and they happen a lot. Okay, so SEP litigation is like an ocean of cases, not in India, but in US, UK, and Europe. There is massive litigation and massive jurisprudence. So I took some important decisions which courts have given there. In the US, there's a case called Georgia Pacific Corporation versus United States Private Corporation. So this is an old case in 1970, even though this case was not directly related to FRAND, but this case was about how to determine reasonable royalties when it comes to patent infringement. So the court listed out 15 factors, which courts must consider while determining reasonable royalties. So among those factors, the most important one is where the court suggested that you should consider a hypothetical negotiations approach, where royalty rate should be those rates, in case, if these two parties removed from the SEP system, outside the SEP system, how they would have negotiated this, how, where royalty rates should correspond to what the parties would have concluded in a hypothetical scenario, where both of them are willing to negotiate at the time of the infringement of the patent. So this, the court said, because generally the SEP holders try to monetize the fact that their standard became their patent became a standard. So this is wrong. Why? Because you can only recover how much you have contributed to the technology. You cannot recover the costs of your technology becoming a standard. Okay, so this is what the hypothetical negotiations approach is. The court asked, suggested that while determining royalties, this is the approach the courts need to follow. And this has guided the courts in the US for good 30-40 years. And then you have, in 2012, there was a case between Microsoft and Motorola, and where the court recognized where the court recognized the peculiarity of SCPs and suggested that while determining reasonable royalties, court must consider the contribution of the technology to the standard and to the final product. Court said you cannot, recover costs of your patent becoming the standards. You actually have to see what is the contribution of the technology to the standard, and also what is the contribution of the technology to the final product. See, for example, if your technology is is so transformative, it's so new that the product is entirely changed. For example, 5G is said to be a transformative technology. There are so many users of 5G. You can probably drive a car using 5G. Surgeries can done remotely using 5G because of lower latency speeds and high transfer rates, meaning it is very fast. Okay, so if it is transformative in nature, and so you should be compensated for the contribution accordingly. But if it is a small patent, if it does not have much value, to the final product, then you probably should not be recovering that much cost. That is what the court said. So then the court came with, then in Ericsson versus D-Link systems, the court suggested an incremental value approach, where the court looked at the incremental value, the current technology added to the standard over the next best alternative available. Okay, so the court complicated this a little more, saying that you base your royalty rates depending on how good the technology is over the next best alternative. For example, like I said, probably SSOs, standard setting organizations, while determining the standards, they look at so many standards and they pick a few. Okay, so suppose there was A, B, C, D, and they picked A and B, and they let C and D go. So while determining royalties for A and B, here, if you transpose this judgment into my example, it will mean that, you will see how good was A and B over C and D. Suppose, for example, in percentage terms, if I say, if it was 20% good, so probably that incremental value, that is called the incremental value. So that is what the court is saying. You have to base your royalty rates on the incremental value. So as you can see that there is no consistency in the courts. So there's no consistency in the US or even in the EU. There is no consistency between what is FRAN. Each judge comes up with their own FRAN analysis and their own ways of determining FRAN royalties. Here, then there are certain anti-competitive concerns of the SCP system. Okay, so because of this SCP system, people found out that the SCP system is probably triggering competition law as well. It is hurting, it has antitrust concerns, and their patent hold up, royalty stacking, threat of injunctive relief, and over declaration. I will deal with each of them separately. Okay, first coming patent hold up. Patent hold up occurs when SCP holders engage in opportunistic behavior by charging implementers high royalty rates for licensing their SCPs. Okay, since I told you, if you remember, like 10 minutes ago, that this whole SCP FRAN situation puts the implementers of puts the SCP holders, meaning the entities which own the standardized technology, in a higher bargaining power, than the SCP implementers. So what they do, there have been a lot of cases where the SCP holder took advantage of his position. And he took advantage of the position the SCP implementer is, the position where he has to implement. He's already invested some costs. So there is no way, only two options are there with the SCP implementer. He can either withdraw from the market completely, or he pays the higher royalty fees, and bears the cost. So what they do, they take advantage of this situation, the SCP holders, and they charge higher royalty rates, or they say that I will not license to you. So this creates something called patent hold up. where the technology is held up somewhere. The implementer is locked into the market that he cannot withdraw now, and nor he can't even move forward. So the manufacturers or implementers of the standard willing to make a standard compliant product must use the SEPs which are incorporated into the standards. If they do not, their devices will be incompatible with the other devices in the market and hence become unmarketable. This scenario gives the SEP holder a higher bargaining power than the implementer or the licensee, as there is no alternative technology which can be used. This SEP holder does not even have an alternative technology which can be used, because if he wants to manufacture a standard compliant product, he has to follow the standards. There is no alternative to a standard. Okay, and even in cases there is a possibility of looking for a standard, it is too expensive. So that is on paper it is possible, but in reality it is not possible. Implementers are in this locked-in position as they make sunk investments in the nature of R&D. This is exacerbated due to the non-availability of competitive alternatives to the SEP and the additional cost they would incur in exploring new technologies. Okay, so there is no other competitive technology available. There is no alternative technology available which is giving competition to this SEP. And also there is no there's a lot of cost involved in exploring new technologies. So in these cases, patent holdup occurs, and this in turn has effect on competition, because the manufacturers are scared to enter the market because they cannot afford these royalty rates, and they withdraw from the market, or they transfer those costs to the consumers at the end. So all these things, they have some effect on the market and on competition. Okay, the Competition Commission of India, the CCI, in the case of Micromax versus Ericsson, observed that holdup can subvert the competitive process of choosing among technologies, because there will be lesser technologies available to the consumers, because most of the manufacturers will not be able to afford that standard. And ultimately, the high cost of such patents get transferred to the final consumers. Okay, so this is what the CCI observed in that case. Then next concern you have is about royalty stacking. So royalty stacking refers to a situation where an implementer must pay royalties to the multiple parties in order to commercialize the product. The royalties are said to be stacked on top of one another. Okay, so this happens in often. Why? Because say you have your phone, and your phone has I think more than 1,000 standardized technology, even more. So our phone manufacturer, suppose you're using an iPhone, so probably that Apple guy has to get licenses from so many people, and when he gets those licenses from so many people, and that means he has to pay royalty to them individually. So this creates a problem, because each of them want to have a share in the royalty, right? So when these royalties get stacked one top of another, sometimes they exceed the entire value of the product itself. There was a case with Xbox where the product, the price of the Xbox was lesser than the royalties that Xbox was going to pay. So this is how royalty stacking occurs. There is a threat of injunctive relief. Okay, so you have to understand that even though this is a standard essential patent, this is still a patent. The person who holds the standard essential patent, say for example, Ericsson, if we take the example of Ericsson has a lot of 5G patents with them, and then he's still a patent holder. In the eyes of law, he's still a patent holder. Even though he has committed his patents to the SAP system, he's still a patent holder. That means he has all the remedies of a patent holder available to him. So they use this, this to their advantage. How? Because whenever licensing negotiations fail, So whenever manufacturers try to negotiate the license and the licensing negotiations fail for some reason, but often what happens is the manufacturer is already using the technology even before the licensing negotiations conclude, because that is how fast the market is. If you don't do it today, probably it will expire by tomorrow. That is the kind of market ICT sector is. So he will be already using that technology. So what happens whenever the licensing negotiations fail, they don't fall through, they don't come through, the SEP holder threatens to file an injunction, apply for an injunction in the court. He'll say that if you don't accept my licensing terms, I am going to file for an injunction against you, that you will never be able to use my technologies, my patent technologies again. Okay, so this is how the threatening happens. Again, this will have a negative effect on competition again, for the same reason as patent hold up has, is that these manufacturers are discouraged from even negotiating, because they are scared that if they don't agree to the terms, they will they will have an injunction slapped on them. So this is how it gets affected. Then you have a problem of over declaration. So whenever these standard setting organizations invite its participating members to declare if they have any relevant patents to the standard being developed, so they are allowed to declare how many ever patents they want. So for example, the European Standard Setting Organization, ETSI, it requires patent holder to disclose all patents which may be potentially essential. So this potentially essential becomes a very big umbrella term. So that means more often than not, these SEP holders include even irrelevant patents into the standard. So they will be having patents which which do not get licensed easily. So they will do this tying and bundling, and they will they will say that these are all the essential patents. And these standard setting organizations, unfortunately, do not do any essentiality checks. So if they did essentiality checks, what is an essentiality check? An essentiality check is a process where you determine whether the disclosed patents are actually essential to the standard or not. So more often than not, these SSOs do not, do that essentiality check. So who does this? During when this SAPs go to litigation, the manufacturer ends up doing the essentiality check to prove to the court that this patent is not even essential, but still so much royalty is being asked. Okay, so this whole thing causes something called over declaration. It occurs when an SCP holder asserts that his patents are essential to a standard, but in reality, the standard can be implemented without implicating the SCP holder's patents. He claims that his patents are essential to a standard, but in reality, that's not the case. You can comply to standards even without implicating this person's the SCP holder's patents. The SCP declaration is a voluntary process where SSOs invite its members to flag their patents as essential if they're relevant to the standard being developed. There are no checks to verify whether the alleged patents are truly essential or not. SSOs such as ETSI require patent holder to disclose all patents which may be potentially essential. This results in inclusion of non-essential patents in the standard, like we discussed. Over-declaration causes inaccuracies in the judicial assessment of FRAN royalties and breach of FRAN litigations. Why? Because when there are too many patents involved, the 10 patents involved, the royalty naturally increases. The courts will also calculate royalties based on the number of patents. So this will lead to inaccuracies in the judicial assessment of FRAN royalties. Okay, so these are certain anti-competitive concerns of the SCP system. Then this is the last part of my presentation, which relates to SCP litigation in India. So I have chosen a couple of important cases. This is the most recent case, InterDigital versus Xiaomi. So Xiaomi is a a mobile manufacturer, like you all know, and InterDigital is a SAP holder. So they were licensing InterDigital possesses 3G and 4G SAPs, which it offered to license to Xiaomi. However, the licensing negotiations between the parties failed because whatever price Xiaomi said it will pay for InterDigital's patents, InterDigital did not find them friend, so it did not accept, and it filed a suit for infringement against Xiaomi because Xiaomi, like I said, was already using the patents because that's the general practice where the manufacturers they use the patented they use the SAP even without license because for whatever reason they're sure that they will get a license. Okay, so it claimed that the rate is not friend, filed a suit against Xiaomi for infringing its 3G and 4G patents as Xiaomi used InterDigital's SAPs without license. So for determining a FRAND royalty, Xiaomi claimed that it needed information regarding the identity of third-party licensees, the exact area and scope of the license granted to such licensees, and other information from comparable license agreements. So since InterDigital was saying that the FRAND, the royalty which Xiaomi is offering to it does not feel like FRAND, so Xiaomi said, so let's determine a FRAND royalty. For that, give me information regarding the licenses you've given to other players. So these companies like InterDigital, they obviously do not limit themselves to one manufacturer. They give licenses to several manufacturers. So they said, you give me the identity, tell me whom you've licensed to, and you give me information regarding on what terms you have licensed to them, and the exact area and scope of the license granted to such license. So it basically said we will determine a FRAND royalty by using comparable licensing agreements. So InterDigital refused the access. InterDigital said that I will not be able to provide this confidential commercial information to you because you're a competitor and you do not want to disclose this. So it instead proposed that we'll have a confidentiality club created where only the advocates and the experts would have access to these documents. So this is what InterDigital said. So since I am not able to provide you the confidential documents, since you're a competitor, so InterDigital proposed that let's have a confidentiality club where only advocates and experts of both the parties will have access. So it didn't want, effectively, it was preventing Xiaomi from having access to these documents, for which the Delhi High Court refused refused the proposal of Xiaomi InterDigital, saying that we cannot have a confidentiality club because this would mean Xiaomi's representatives negotiating for Xiaomi without consulting their client. So it said the lawyer should act on the instruction of the client, but the lawyer should not, substitute their judgment for the client. So the lawyer is merely a representative. The client cannot be in a complete blind of the, of the negotiations. So the court rejected. So while all this was happening, it was learned that a month ahead of this suit, so this happened in July, in June, Xiaomi filed a suit in Wuhan court for the determination of FRAND royalties. So you have to understand that these licenses happen all over the world because patents are territorial in nature. For that reason, if a case is filed in one country, you can be assured that a similar case is filed in another country because manufacturers market their products in all over the world. So Xiaomi already filed a suit in the Wuhan court for determination of FRAND royalties. And in retaliation, InterDigital filed the current suit in Delhi High Court. So, why did it do that? To gain some leverage in the Wuhan court, saying that suppose it gets a favorable judgment in the Delhi High Court, it thought that it can present that judgment in the Wuhan court and saying that, the Delhi High Court in India gave me this order in favor of me. So probably it will persuade the Wuhan court also to do the same. So, so what the Wuhan court did, the Wuhan court issued an anti-suit injunction against InterDigital, preventing it from pursuing the suit in Delhi High Court. So anti-suit injunction, prevents you from pursuing your suit in other jurisdictions. So anti-suit injunction is generally given to stop forum shopping. So the Wuhan court issued this anti-suit injunction and preventing InterDigital from pursuing the suit in Delhi High Court. In retaliation, InterDigital filed an anti-suit injunction in the Delhi High Court, asking the Delhi High Court to direct Xiaomi from pursuing the court in the Wuhan court. So the Delhi High Court accepted the application. The Delhi High Court granted its first anti-suit injunction in this case. So this is where this case ended. So as you can see that this case did more to CPC than it did to your standard essential patents. So there was no discussion about FRAND royalties or what is if abuse of dominant position, nothing, but the proceedings ended here. And this anti-suit injunction is called the latest problem of the new entrant in the problems of the SCP system. Besides the patent hold-up, royalty stacking, over-declaration, threat of injunctive relief, anti-suit injunctions are the new problems of the SCP system. And then you have my Ericsson cases. So your SCP litigation in India started with Ericsson cases. So the certain disputes arose with Ericsson and and the local manufacturers like Micromax, Intex, Eyeball. So the many cases, I just picked out two where starting 2013, all this started. So these cases have been pursued in both Delhi High Court and Competition Commission of India, different cases. So in Competition Commission of India, Micromax filed a complaint with the CCI against Ericsson, alleging that Ericsson abused its allegedly dominant position by imposing exorbitant royalty rates for the use of its SCPs, thereby violating Section 4 of the Competition Act, which deals with abuse of dominant position. So Micromax said that Ericsson is demanding high royalty rates for the use of its SCPs and hence abusing its dominant position because there is no other alternative to Ericsson's patents. They have to use Ericsson's patents. So then Micromax's contention was that royalty rates must not be calculated on the entire market value of the final product. It's a mobile handset, but should be based on the value of the chipset in the phone. Okay, so here the issue was Ericsson was calculating its royalty rates on the entire phone. So Ericsson was saying, I want this much percentage on the phone. And Micromax was saying, why should I give you royalty rate on based of the final product when all you did was give me a small chip, a chipset in the phone. This was for I think GSM and CDMA. So that was the dispute, that Ericsson was demanding the entire market value as a royalty rate based on it, and Micromax was saying that I will only give you on the chipset. So this is called entire market value rate, that is EMVR versus smallest saleable patent practicing unit, SSP. Okay, you must have heard of it. So this was the issue for which and Micromax added that Ericsson is the sole licensor of the SCPs and took advantage of there being no alternative technology available. And CCI held that Ericsson held a dominant position in the market for devices that implement GSM or CDMA standards. It also stated that Ericsson's royalty rates were excessive and discriminatory, as a royalty base was the entire market value of the product instead of a percentage of the price of the GSMA or the CDMA chip. So the CCI concluded that the requested royalties had no linkage to the patented product and were thus discriminatory as well as contrary to FRAND terms. So this is what the CCI said. CCI said it's unfair to demand licensing fees on the entire market value of the product when you have the contribution of the SEP holder to the final product is a small chipset, although very, very important, but still there's so many other elements which the manufacturer must have contributed, which the SEP holder had no contribution to. The SEP holder didn't have anything to do, say, for the design value of the phone. The SEP holder only has a contribution in that chipset. He does not have, say, for example, recently I saw Xiaomi having a detachable camera, a selfie camera. So if the SEP holder is demanding on the final product, then it is asking for a share in those design patents as well. So which seems unfair. The CCI said. The CCI followed the entire market value rate, and then it said Ericsson was abusing its dominant position, and the rates quoted by Ericsson were against FRAND terms. The CCI unfortunately did not go into further details, talking about why it is not FRAND or discussing what is FRAND, because it was a good opportunity. A similar case was filed in the Delhi High Court between Ericsson versus Intex. Here, Ericsson filed a suit against Intex for infringement of its 2G and 3G SCPs, seeking a permanent injunction and damages. So, Intex was using Ericsson's SCPs related to 2G and 3G, and seeking. So, Ericsson filed a suit against it, seeking permanent injunction and damages. Intex claimed that Ericsson violated its FRAND obligations as it charged more royalties from them compared to Micromax and Joni. So here the non-discriminatory clause came, where Intex was claiming that Ericsson charged them more than they charged Micromax and Joni. It contended that Ericsson demanded royalties based on the entire market value of the product instead of the percentage of the chipset value. In this case, the Delhi High Court, in contrast with the CCI, said that Ericsson's practice of charging royalties based on the price of the downstream device is FRAND. It simply said that this is valid, this is fair, reasonable, and non-discriminatory, charging on the entire product value, because one reason the Delhi High Court said that was because it's the market practice. Even in countries like USA and EU, they all follow, entire market value rate, because, according to them, SSPU is very difficult to determine. So this is the incompatibility between CCI and Delhi High Court, which happened. So this is what I wanted to highlight. Okay, so this is what standard essential patents are, and there's some issues related to it. Thank you.
Thank you for a wonderful presentation, Srinidhi. I think it was very, very informative, illuminating. Now, I would like Mr. Srinivas Rao, our colleague at the DPIIT IPR-Chair, to propose formal vote of thanks. Over to you, Srinivas.
Thank you, madam, for being here and added a start to our platform, which is dedicated to research, knowledge, information, and dissemination of IPR base altogether. You picked up a niche topic today, which talks about interoperable technology talking to each other, settings of standards in any kind of patents. In brief, we interpret your session as the standard essential patents are those patents which are standard compliance products which are regulated by standard setting organizations. You have precisely defined every aspect of SAP and fine-tuned to FRAND. Then you talked about FRAND also, which has, in your terms, has no definition, but you refer to a case of Georgia Pacific Corporation versus United States Plywood Corporation 1970. And you talked about, and with that you talked about the other cases also, which includes the cases between Micromax versus Ericsson and introduce the doctrine of dominant position and nicely interpret along with that of the CII provisions also. So in your concluding session, you have nicely presented the case of InterDigital versus Xiaomi, which is an eye-opener in many ways, and all the cases you described were nicely in the form of a brief stories, which is the highlight of today's session. So here on behalf of DPIIT IPR-Chair, OU Hyderabad, India, I would like to thank you and thank all the participants for attending this session and encouraging our work every week. With that note, hope to see you all once again. And now we would like to conclude this session here with the consent of the chair. Thank you. Thank you, madam.
Thank you, sir. Thank you so much.